Hi everyone, you're watching the Virtual Amicus and I'm Jay Lodha. Well, today's discussion is on Real Estate Regulation and Development Act 2016 and quite specifically with regulatory authorities that are constituted under this very act. And why this act came into force, what was the need? We all know that how civil courts and consumer courts in India are overburdened with cases. There are a huge piling of cases that is happening. So we needed that forum, we need that designated special court that could specifically deal with disputes that were arising out of real estate sectors, where home buyers could file complaints for non-grant of possession. It was basically protective gear for a home buyer, to regulate developers, and most importantly, to increase investments and to promote transparency. Now, we all know that there is a provision that is there under the provisions of the Act for the purpose of constitution of regulatory authorities that are catering to the role of adjudication, arbitration in real estate matters. And apart from that, a RERA complaint can also be filed for issues like a restoration of project, delay in possession, no details about project, statutory and structural defects, ownership transfer, and etc. and etc. Now, joining us today is a lawyer par excellence, is a very special guest. He's a former national level tennis player, and today he's joining us in the capacity of a seasoned advocate. We have with us Mr. Dhruv Gupta. Mr. Dhruv Gupta, thank you so much for joining us on a Sunday morning. He's presently a founder partner at KD Law Associates law firm, which is a corporate-based firm. And just to give you all a brief introduction about Mr. Gupta, he initially did his graduation from the SVKM Narsi Munji Institute of Management Studies, where he did his bachelor's in commerce honors back in the year April 2011. Subsequently, he did a course in law of financial services and capital markets in 2013. This was jointly conducted by the Institute of Insurance and Risk Management at Hyderabad. And then he did and studied his law, which is LLB, from the Campus Law Center, Faculty of Law, New Delhi. Now, he has an amazing profile, but we had to cut short his list of achievements owing to the paucity of time. And he's worked in the esteemed chambers of Senior Advocate Dr. U.K. Chaudhary, President, NCLT Bar Association, where he practiced majorly before National Company Law Appellate Tribunal and National Company Law Tribunal, New Delhi. He's also practiced in the esteemed chambers of Senior Advocate Mr. Aman Lekhi, Additional Solicitor General, Supreme Court of India, and he worked there from March 2018 to February 2019, total for a period of 1 year. And prior to that, he worked in the chambers of Senior Advocate Mr. Amarjit Singh Chandiok, who is the former Additional Solicitor General in New Delhi. He worked there from July 2017 to February 2018. And what I said in the beginning of the presentation, we have with us a former national level tennis player. He was also the former Rajasthan State #1 tennis player in two categories, under 14 and under 18. Wow. And today he's a lawyer par excellence. So thank you so much, Dhruv. I understand today we have the French Open finals. Today is also Sunday morning. Yes. So thank you so much for taking out time in spite of being such a big tennis enthusiast and a player yourself. So over to you. The stage is set. Please proceed.
Right. Thank you so much, Jeff, for the wonderful introduction. It gives me immense pleasure to talk about a topic that a lot of people can relate to, not just home buyers or unit allottees, but also promoters or builders. So therefore, I think this is the topic that a lot of people can relate to. Now, without further ado, I will share a presentation that I've made on this so that it is easier for the viewers to track what we are speaking about. Now, today, the topic that I am slated to speak on is the Real Estate Regulation and Development Act 2016. To understand any law in its correct perspective, it is important to understand the historical perspective of the legislation or the background in which it has come to be enacted. Prior to the enactment of RERA 2016, the Town and Country Planning Acts of the respective states provided for control and growth of land use, whereas ownership of apartments came under the Apartment Ownership Acts of the respective states. Now, beyond this, the sector was largely unregulated. And owing to the dearth of regulation, the grievance redressal for allottees for home buyers was under the Consumer Protection Act, which was a curative piece of legislation and not preventive. Now, to address this issue, the Real Estate Regulation and Development Act came to be enacted in 2018, and the objectives are highlighted in the preamble of the legislation. Now, without having to read through the entire preamble, there are certain keywords that I've highlighted in blue and red. Now, these keywords highlighted in blue state the purpose with which, or the object with which the RERA came to be enacted. Now, if you read these words, the RERA has been enacted for the purpose of regulation and promotion of the real estate sector. It has come about for the purpose of increasing efficiency and transparency in real estate dealings and to protect the interest of consumers, as well as to provide speedy dispute redressal mechanism. And for that purpose, it establishes the real estate regulatory authority. It establishes an adjudicating authority, an adjudicating officer, and also it establishes an appellate tribunal for that purpose. Now, for those who would be interested in understanding the legislative competence behind enactment of RERA, uh, under the seventh schedule to the Constitution of India, list 2, which enumerates the subjects on which the state can legislate, entry 18 talks about legislation on land. Now, the question that beckons consideration is, when the central government enacts RERA, does it amount to a legislative overreach? The answer to that question lies in the third bullet point of this presentation, which is under the seventh schedule in list 3, there are 2 entries, entries 6 and 7, which talk about the transfer of property. They talk about registration of deeds and documents, contracts, including partnership, etc. Now, now RERA has been enacted by the central government in exercise of powers under list 3, entries 6 and 7. List 3 enumerates subjects which are subjects of under the concurrent list. Now, Article 254 of the Constitution states that in case of any repugnancy between the central law and the state law on matters enumerated in the concurrent list, it is the former that prevails over the latter. Therefore, the question of legislative competence gets answered over there. Now, before adverting to the important definitions and provisions under the Real Estate Act, the Real Estate Regulation Act, I would like to share a very, very valuable piece of advice that I've been given by one of the senior advocates that I've worked with, which has stayed with me till date. My senior always used to tell me that to understand any law properly, it is very important to understand each and every provision of the legislation rather than jumping onto judicial pronouncements. That is because judicial pronouncements are basically interpretations of these provisions by judges. Now, to remain unbiased, to give it your own flavor, one must definitely go through the provisions in detail. Now, having said that, that is precisely what my endeavor today is. And for that purpose, I will be focusing only on the very important provisions. We'll start with the definition of allottees and promoters for the reason that these are the prominent aspects of the Real Estate Regulation and Development Act. Now, allottee under the RERA Act has been defined to means the person to whom a plot, apartment, or building, as the case may be, has been allotted, sold, or transferred, and also includes the person who subsequently acquires the said allotment through sale, transfer, or otherwise, which means that it is not just the immediate purchaser of the property, but also somebody who is ultimately the beneficiary of such a transfer. So therefore, if I purchase a property and if I sell it off to somebody else, that somebody else can also derive the benefit under the RERA Act. Now, promoter has been defined in the legislation to mean a person who constructs or causes to be constructed an independent building or converts an existing building or a part thereof into apartments for the purposes of selling. Now, the important provision, the important word terms to keep in mind over here is that it is not just a fresh construction, a new construction that is coming up, but also where an existing building has been renovated, but for the purposes of selling. Now, that is what is covered by the definition of promoter. Now, promoter under the RERA Act does not only mean a private entity, a private builder, but also covers development authority or any other public body, provided such a development authority or public body is the one that is constructing the project, is constructing the building or the apartments. So therefore, these are the two important definitions. Now, insofar as the applicability of provisions of RERA are concerned, they apply to apartments, buildings, plots, and real estate projects. Most of these terms are self-explanatory, therefore we do not need to go into the definition of all of them. But insofar as apartment is concerned, this is the definition that sticks out for the reason that apartment has been defined in a sense, not understood in the common parlance, but it goes beyond that. Because under the Act, apartment also includes a block, a chamber, a dwelling unit, flat, office, showroom, shops, godowns, so on and so forth, or any other name means a separate self-contained part of any immovable property. Therefore, under the definition of apartment, there are a lot of other units of different kinds that are covered. Now, having said that, we'll move on to the important provisions to understand how exactly RERA operates. Now, under Section 3 of RERA, it is mandatory for every real estate project to be registered with the Real Estate Regulatory Authority. However, under subsection 2 of Section 3, there are certain exceptions that have been carved out. One of these important exceptions, I will not refer to all of them. One of the important exceptions that has been carved out for the purpose from the mandate of registration is under subsection 2, subsection C. This is no registration of real estate project shall be required for the purpose of renovation or repair or redevelopment, which does not involve marketing, advertising, selling, or new allotment of any apartment, plot, or building, as the case may be under the real estate project. Which means renovation, repair, or redevelopment, which is not meant for sale or not meant to be marketed, will not be covered. So now, Section 4 of RERA provides for the mode and manner of making an application to RERA for the purpose of registration. Now, under Section 4, the promoter is required to make an application, and along with the application, he is required to place on record certain documents for the purpose of registration. He is also required to make certain disclosures. Now, one of the important disclosures he is required to make is he has to give a detail of the projects that have been launched by him in the past 5 years, whether already completed or being developed, as the case may be, including the current status of the said projects, any delay in its completion, details of cases pending, details of type of land and payments pending. Now, this is important from the buyer's perspective to identify the credibility of any builder. Along with the application, the promoter is also required to make disclosure about the time period within which he undertakes to complete the project or phase thereof, as the case may be. Now, finally, there is another incumbent requirement for the purpose of registration, which has been specified in Section 4, subsection 2, subsection D, LD, wherein it has been mandated that any promoter who wishes to be registered under the RERA Act will have to open a separate bank account with a scheduled bank, and wherein he has to necessarily earmark 70% of the amounts realized from the real estate project from the allottees from time to time, and it will be used only for the purposes of development of the real estate project in question. Now, like there are requirements, like there is a mandate for registration of a real estate project, there is also under Section 9 a requirement for registration of real estate agents. We will not be adverting to the various provisions of Section 9. Now, under Section 11, the functions and duties of promoters have been clearly specified. Now, the important part here is that a promoter, each and every promoter under the Real Estate Regulation and Development Act, has to create his web page on the website of the authority and enter all the details of the proposed project, such as details of registration granted by the authority, the quarterly up-to-date of the list of number and types of apartments or plots which are being developed and which have been booked. So he's required to specify all of that. Under Section 11, subsection 4, there are very important duties of the promoter that have been highlighted. We'll only identify two such important provisions. Now, the promoter is required to pay all outgoings until he transfers the physical possession of the real estate project to the allottee. Now, these outgoings are in the form of land costs, ground rent, municipal or other local taxes, or charges for water or electricity, and maintenance charges. So until and unless he's given possession of the units to the allottees, it is incumbent upon the promoter to make all these payments. Where the promoter, even though he hands over the possession but does not make payments which were pending prior to such handing over of possession, he continues to remain liable by virtue of the proviso to subsection 4G. Under Section 4, subsection 4, subsection H, which is another important provision, it mandates that after an apartment buyer's agreement or an agreement to sell has been executed between a promoter and an allottee, the promoter cannot create any charge or cannot create mortgage over the said apartment, plot, or building, as the case may be. Where such a charge is created, contrary to the provision, the promoter continues to be liable for such a charge, and it is not binding on the allottee. Moving on. Under Section 13 of RERA Act, it has been mandated that a promoter cannot accept an amount over and above 10% of the cost of the apartment, plot, or building as an advance payment or an application fee from a person without first entering into an agreement for sale. Now, this is important for allottees to identify so that they are not exploited and they're not made to shell out money over and above 10% prior to the entering into an agreement for sale. Under Section 14, Section 14 talks about adherence to sanction plans and project specifications by the promoter. Now, one of the important provisions here is Section 14, subsection 3. Now, even though the possession may be handed over to an allottee by the promoter, but the promoter identifies certain structural defects or defects in workmanship. What happens in such a case is that in case any such defect is noticed by the allottee after handing over of possession, but within a period of 5 years from the date of handing over of possession, it shall be the duty of the promoter to rectify such defects without any further charge, and it has to be done within 30 days. Now, this is another important provision that I believe all allottees should be aware of. Section 18 talks about the consequences, what happens where there is any breach of obligations by the promoter. Section 18 talks about the return of amount and compensation. Where the promoter fails to give the due possession of the apartment, plot, or building, as the case may be, within the timeline stipulated, as he discloses at the time of registration, he shall be liable to pay on demand to the allottee in case the allottee wishes to withdraw from the project without prejudice to other remedies available to the allottee, to return the amount received by him in respect of that apartment, plot, building, as the case may be, with interest at such rate as may be prescribed. Now, where an allottee does not intend to withdraw from the project, he shall be paid by the promoter interest for every month of delay till the date of handing over of the possession at the rate as may be prescribed. Now, this is yet another important provision that must be taken into account. Section 19 talks about the corresponding rights and duties of allottees, such as that the allottee must make timely payments. In case of any delay in making timely payments, the allottee is equally bound to pay interest on delayed payments. So these are some of the rights and duties that have been enumerated in Section 19. Now, if in case, now the other important provision is Section 31. Now, where anybody is aggrieved, any aggrieved person may move an application in case there is anybody who is aggrieved by any act of the promoter, or where the promoter himself is aggrieved by some act of the allottee. He can move an application under Section 31 to the Real Estate Regulatory Authority Act, which has been established under Section 20 of this legislation. Section 31 states that any aggrieved person may file a complaint with the authority or the adjudicating officer, as the case may be. Now, once an application is made under Section 31, under Section 34, it is incumbent upon the authority to ensure compliance of the obligations cast upon the promoter, the allottee, and the real estate agents under this act, as the case may be, and the rules and regulations made thereunder. So therefore, it is incumbent upon the authority to ensure that the provisions of the act are complied with and all the disclosures are adhered to. Now, under Section 36, powers to issue interim direction to the authority is also given. Now, this is a very important provision because this helps in preventing any continuing breaches of obligations that are presently ongoing. Under Section 36, the authority can, by order, restrain any promoter, allottee, or real estate agent from carrying on any such act until the conclusion of such inquiry or until further orders, without giving notice to such party where the authority deems it necessary. Under Section 38, the authority can also impose a penalty or interest on the promoter or the allottee or the real estate agent for any contravention of obligations which have been cast upon them under the Act or under the rules or regulations. Section 40 talks about recovery of interest or penalty, compensation, and enforcement of orders of RERA. What it states is that if a promoter or an allottee or a real estate agent fails to make any payment of interest or fails to make any payment of penalty or compensation, the same is liable to be recovered from such person in the form of land arrears. Arrears of land revenue. Now, what that means is that in case of non-payment, the personal assets of the respective promoter, allottee, or the real estate agent can also be attached for the purpose of realization of these amounts. So this is a very stringent provision which is generally omitted from observation, but something that must be taken into account. Now, once the adjudicating officer or the RERA authority has passed an order, the further redressal mechanism provides for an appeal to the real estate appellate tribunal. Now, Section 43 talks about the establishment of the real estate appellate tribunal. Any appeal has to be section 44 prescribes that any appeal from an order of the adjudicating officer or from the order of the RERA authority has to be made to the appellate tribunal within a period of 60 days from the date from the date on which a copy of the direction or order or decision made by the authority or the adjudicating officer is received by such aggrieved person or by such appellant. Now, the appeal that has been preferred before the appellate tribunal must be mandatorily disposed of within a period of 60 days or within such further period as the authority may determine in writing, but it has to give its reasons for why it is extending beyond 60 days. Now, this is a very important provision because this ensures a timely completion of the proceedings and a redressal within a time bound fashion. Now, under Section 44, as I've said, that there is a period of 60 days has been provided for the adjudication of appeal before the appellate tribunal. I believe my laptop is stuck. Just give me a second.
Due to some technical glitches, I could not connect to the speaker. Now I think he's on board. Mr. Gupta, you may proceed. Thank you.
Right. Apologies for the inadvertent, glitch. In any case, moving on from Section 44, which we've already discussed, another important provision incorporated under RERA is Section 58, which gives the right of second appeal to the High Court from the order of the appellate tribunal. Now, what Section 58 prescribes is that any person aggrieved by any decision of the appellate tribunal may file an appeal to the High Court within a period of 60 days from the date of communication of the decision of the order of the appellate tribunal to him on one or more of the grounds specified in Section 100 of the CPC, which basically talks about a second appeal. Now, moving on, Section 71 talks about the process of adjudication of compensation under various provisions of RERA. For instance, Section 12, 14, 18, and 19. Now, what Section 71 prescribes is that for the purpose of determination of compensation under the provisions of RERA, the authority shall appoint, in consultation with the appropriate government, one or more judicial officers to act as the adjudicating officer. Now, this adjudicating officer has to decide the quantum of compensation within 60 days from the date of receipt of the application. Section 79 talks about the bar of jurisdiction of civil courts. Now, this is because of the fact that RERA is a self-contained court. It provides that no civil court shall have jurisdiction with respect to matters which are basically causes of action under the Real Estate Regulation and Development Act. So, this bars jurisdiction of civil courts. Section 88 talks about the fact that the provisions of RERA do not bar the applicability of other laws. It says that the provisions of this act shall be in addition to and not in derogation of the provisions of any other law for the time being in force, which means that provisions of other legislation such as Consumer Protection Act are not barred by virtue of provisions of RERA. Whereas Section 89 states that where there is any conflict between the provisions of RERA and such other legislation, it is the provisions of RERA that will prevail. Now, having stated so, we'll look at some of the important judicial pronouncements with respect to the RERA legislation. The first and foremost important judicial pronouncement is Messrs. Imperia Structures Limited versus Anil Patni and another. Now, this is a case where the Supreme Court was seized of the issue whether the existence of a redressal mechanism under RERA bars any other proceedings from being instituted by allottees or by home buyers. The court was of the opinion that the existence of such a redressal mechanism does not bar simultaneous proceedings under the Consumer Protection Act. And in reaching this conclusion, the court relied upon predominantly Section 88 and Section 89, which we've just seen. Now, another important decision is the Mumbai Grahak Panchayat Suo Moto Inquiry number 17 of 2018. Now, this is the piece. This is the judicial pronouncement by quasi-judicial pronouncement by RERA, wherein the question before it was that these digital platforms such as Makan.com, 99acres.com, are they required to be registered as real estate agents under the provisions of RERA? The court was of the opinion where such a portal does not actively market any real estate project, but it only acts as a facilitating agent so that so that it can display on its platform all the real estate projects that are registered with it. It does not require to be registered under the provisions of RERA. Where, however, such a platform is actively involved in selling any project or any apartment plot to the allottees, then the requirement for registration is incumbent. Finally, another important decision is the Pioneer Urban Land and Infrastructure Limited versus Union of India. Now, this is predominantly a judicial pronouncement in the sphere of insolvency and bankruptcy court. But what the Supreme Court has held in this case is that in case of conflict between the provisions of IBC and RERA, it is the provisions of IBC that will prevail over RERA. Now, with that, I conclude my presentation on the provisions of RERA, and I hope this was of some use to our viewers. Thank you.
Thank you so much, Mr. Gupta. So that was a brilliant presentation by a brilliant counsel. So it is not just the implementation, I think, and I personally feel that it is the effective implementation of RERA that can restore the trust between a buyer and a seller. So thank you so much, Mr. Gupta, for summing it up so well on a Sunday morning. And thank you so much for taking out time from your busy schedule. So hope our viewers will immensely benefit from this lucid presentation of yours. And if you still have any queries of any of the fundamentals or concepts, so query can be conceptual as well, feel free to write to us. We'll be more than happy to forward it as it is to the speaker for today's session, the amicus for today's session, Mr. Gupta, and who's always ready to help anybody, whoever has a query that send. And so thank you so much, everybody, for a patient hearing. Thank you so much for joining us today on a Sunday morning. And stay tuned. Next episode is on its way. Please like, subscribe, and share my channel. Thank you so much, Mr. Gupta, once again for your time and so much effort that you put in. I mean, it was it's so nice to see you coming on a Sunday morning and then putting so much of effort.
It's always a pleasure to discuss law. I mean, and especially some a legislation like RERA, which is so relevant for everybody.
I really appreciate that, and I hope to see you soon. So thank you everyone for watching the virtual amicus. Stay home, stay safe. Please take good care of yourselves and venture out only if it's very essential, because Corona is here to stay forever. Thank you so much. Thank you.